application, there will be an answering affidavit by 1 o'clock tomorrow. Now,
1 o'clock today?
yes. Oh, sorry, 1 o'clock today, this afternoon. My question still stands. So when do you think the papers will be ready, and when will these matters and all the other parties and applicants have a hearing?
We will ensure that we have affidavits in the other three applications ready by tomorrow morning, as early as we can. It's 8 or 9 o'clock. And thereafter we are in new announcement. And then, of course, if it is to be tomorrow, then the Lordship is not going to give us any time to prepare it. It's all not well time. And then, of course,
But in the nature of this, of the application, Mr. Erasmus, and what I've said to Mr. Sabui as well, Friday is too late. At the latest, the matters will have to be heard tomorrow.
We will do our best, but as your Lordship also has to appreciate that we will do our level best, but we will keep in mind that there are three further applications. All these applications run to some up 80 pages and slightly up of that. And we have to read, analyze, and decide how much is different from the application. So, maybe just make it clear. It's of utmost importance that the matter be that the dates are 15 and 17 December, and we are acutely aware of that, and we want the matters to be finalized as soon as possible so that there will be finality involving the new rights. So we are doing our best what we can under very short circumstances.
Let me hear from the applicants again. Mr. Pelser, what are the applicants in 64171, what are their proposal regarding the hearing of the matter?
My Lord, I've listened to my learned friend. He tells your Lordship that it will be ready, the answering affidavit, by 1 o'clock.
In your application?
My application,
yes.
Just mine. Now, so I can't have it earlier, it is just the way it is. But I would urge your Lordship to require from my learned friend why the first respondent is refusing us the record. We asked the record firstly at 6:30 yesterday morning, and I'm not going to go into detail, my Lord, simply because it was a conversation between Mr. Erasmus and myself, but we were fobbed off. Then we wrote a letter to the State Attorney. My instructing attorney wrote such letter, again requesting it, i.e. pursuing another avenue to desperately get the letter, the record. And your Lordship will know that is pivotal in proceedings such as this. Then my attorney was fobbed off with reasons such as, you never requested it in your notice of motion. That is obstructive, my Lord, to say the least. So what I would urge your Lordship to consider is, if the affidavits will be ready by 1 o'clock, we want the annexures to the affidavits, which by now should have been sorted out, we want the annexures in half an hour's time. I submit that's a reasonable approach, and it would assist us to consider...
Sorry, you mean the annexures to the answering affidavit?
Yes. Did I say something differently?
No, I just want to know...
The annexures, well, what we were told is, we will not get the record. What the applicants consider relevant will be annexed to the answering affidavit. So it's not said that that is the full record, but even so, it may assist us to expedite matters if we can have that annexures in half an hour's time. That shouldn't be too difficult. And I would urge your Lordship to order the first respondent to do so. If then we receive the answering affidavit by 1 o'clock, I suggest, my Lord, that this matter stands till 2 o'clock. It may be that there are small things which we may have to answer to reply to. I doubt. But still, that will give us time just to reorder.
Yes.
If that suits your Lordship.
Well, the roll is full and has been allocated earlier, last week already, with other matters also for tomorrow. But these matters have now come in afresh, and there are now others which will not be ready by 2 o'clock and which might only be ready by tomorrow. loath as I am to do so, wouldn't it be better if all of them are heard simultaneously, which can only take place tomorrow?
It will be in order with the applicants in my case.
In your case, all right?
I
So,
will refer to it as SPIS versus the Minister of Basic Education,
yes, thank you, Mr. Pelser.
as the court pleases.
Mr. Stradle?
My Lord, firstly, I just want to say as regarding our application, we are acting on behalf of individuals, and the facts that we've put before the court are all dealing with the individual circumstances of those people. Now, the issues in this case are very much the same as the case of the SPIS matter. Because the points that one has to consider is firstly the legal framework and the regulations that are applicable. And secondly, we have to look at whether it was a rational decision or not.
Well, that's the question in the end.
And that's the question in the end. And then we will have to look at the circumstances of those parties.
Will that issue be a PAJA?
It's also it's a PAJA review from our side, and we're bringing an application for review in our notice of motion. We ask that the decision by the Minister, which she has announced on the 4th of December, be reviewed and set aside. We're coming with a review application. It's a PAJA review, so it's got the legs. The question of the law has to be considered, and the legislative provisions. And secondly, it's a question whether the decision was a rational decision based on proper reasons. So it's very much the same as the case of the SPIS matter. There's no reason for your Lordship to say that these applications should be heard separately.
All right,
We
so
submit from a practical situation that it has to be heard together with all cases. It's no need that we come on Friday because the affidavits are late and the SPIS application was disposed of earlier on the roll because
I think you're right. The more proper approach should be that all the applications be heard simultaneously.
Let it be heard simultaneously, because
All right.
if the one application is disposed of, the horse might have bolted before we had our say in court. So we say it has to be heard simultaneously. We haven't got a problem that it stands down till tomorrow 10 o'clock, but as far as the affidavits are concerned, at this point we want to take up with Mr. Erasmus, and also with, there's no opposition by Umlaluzi in this case. We didn't ask any relief against them. We didn't ask costs against them in our case. But be that as it may, from a practical
So
perspective,
you don't need an affidavit from them in your application.
We don't need it.
But what they say in their affidavit in the SPIS matter, of course, will be relevant to the matter as a whole.
correct, Mark. So we haven't got any objection. If any of the points that are raised against the SPIS matter, although they haven't, if they don't file affidavits in our case, because it's the law and the rationality, that it also be raised against us.
So you almost say, irrespective of whether you get an affidavit or not, the principal issue is they should be heard simultaneously, and you have no objection to hearing them, to them being heard tomorrow at 10.
Yes,
And it
from
seems Mr. Pelser's matter will be also ready tomorrow at 10.
that is so, Mark.
And I don't know about the application in Bembe, but I think,
My Lord, just if you allow
Yes.
me, before we get there, in our case, because we've got a review application, we in fact, in our notice of motion, asked for the record. And it appears on page 3 of our papers where we say, hand to the registrar not later than 15:30 on Tuesday, the 8th of December, the record of such proceedings. As it is a review application, although by way of an urgent application, there's no conceivable reason that this record not be given to us. And we will ask that this record be given before 1 o'clock today. Perhaps even earlier. We must consider the record and see whom has made the decision and what is the basis thereof. We can say 12 o'clock is perhaps better, my Lord. Then we can consider our case from there onwards. But basically, the issues in this case are very clear. It's simple. There's no need for although I don't deny my learned friend the right to file answering affidavits, I haven't got a problem if the issues that are being raised in the SPIS matter also be raised against us. But I'll discuss it with him as well, my Lord. But I think we need a practical approach to have this matter finalized by no later than 10 o'clock tomorrow. My Lord, and as far as tomorrow is concerned, it can't be decided later. My clients are under stress. There's uncertainty. It must reach finality. They must know whether they're going to write the exam or not.
I've seen their affidavits. I think they're in the similar position as the individuals in the other matter, Bembe 64222 of 2020. Mr. Sibui, in your matter?
Yes, my Lord. Like the other present applicants, we are seeking also to review and set aside the decision of the Minister, and based on the principle of legality and also parja.
Well, it's either legality or parja, whether it's executive or administrative decision, yes.
So,
rationality plays a role.
yes. So we are saying also the issues are so clear that I do not think whatever answering affidavit they will bring will change the issues before you, and we will be able to argue. Even without filing the client affidavits.
10 o'clock tomorrow.
10 o'clock tomorrow.
You'll also be happy with the record in the meantime.
Yes, we are on the same board in the record. We also need the record, but I'm not sure whether there's any record.
Yes. Lucy, if I can call the respondent that. Any issue on, if the matter stands down until 10 o'clock, matters all stand down until 10 o'clock tomorrow.
And I suggested that eventually that we agree each time period for all the matters so that they will be good. If we allocate amongst ourselves.
I think you can allocate that amongst yourselves. Look, I'll have to hear the applicants in all four matters.
Is that how you?
Then I think a simultaneous and a joint hearing should be rather than piecemeal and rather than disjunctively. So I think it'll be appropriate if I hear the applicants in all four matters, then the principal respondent, the minister, dealing with all four matters, Lucy with all four matters, and we'll see whatever is left then for reply.
In three and only sources, I will only be at this stage dealing with the first instance.
Yes, the one in which you delivered an answering affidavit. Yes. Thank you. Mr. Erasmus, lastly, again, the respondent. I propose to have the matter stand down until tomorrow at 10 to order you to deliver or to make available the record to the other parties. And I will note that you have undertaken to give your answering affidavit in the first matter by 1 o'clock today. Whatever else you then do or see fit regarding answering affidavits, the other parties will deal with. The factual issues should then have been canvassed, and the remainder will more be then of a legal argument nature.
What we will do is first of all to file affidavits at least because we know what's going to hear, what's going to happen. You don't answer in any of the other applications. The argument is advanced, but you haven't answered if you submitted. So we have to deal with it. With the greatest of respect, one can't deal with an issue like this of national importance on a very basis. So we're going to file affidavits. We'll do our best for tomorrow morning, my Lord. And I think the mere fact that we barely stepped for the last 2 months is testimony to that. I just have to deal with the question of the record. The other question that we refuse to make available the record. And what we have said yesterday morning to now extract all the documentation that the department may have in about 3 or 4 hours to compile a record was counterproductive from here. And as we have said from the word go, we will annex all the documentation to our opposing affidavit. We have done some of it. I don't know how many pages it is. I just know last night because we collated whilst we were preparing the affidavits, all of them. I know it's about that much, it's over 100 pages for all. What we've done is that the documentation sent to us, we have already marked and placed them in sequence for it. So it's not at the state attorney nor at my chambers to look. So it is at the department, what I will do with you. And request the parties who would like to get it.
After you've said all that, Mr. Erasmus, how long will it take you?
Can we just make copies of it, the law? Can we make copies during the course of the morning, let's say by latest 1 o'clock? It should be available for the documentation. And I may find out the spokesperson of the minister also important, or also the president, that I will contact Mr. Leepers myself as well, ask him to start my copies of all the annexes and have them available. And it looks like we've got to have 1, 2, 3 copies of all.
So there is a set of documents available which would constitute your version of the record.
Correct.
What is necessary to be done is to make copies of them,
Yes.
to make them available to the other parties. Well, surely that can't take 2.5 hours.
Well, my lord, I'm going to find out. I say at the utmost, but I don't know what is happening at the department, but the lordship should keep in mind the same official has to arrange for the commissioning of 1, 2, 3, 4, 5, 6 affidavits. So there are 6 components, get all of them, but we'll do it as soon as we can.
Yeah, but you can send the copies of the documents at least.
Yes, well, my lord, as long as I can arrange with Mr. Leepers and to get it from Mr. Leepers, it's just down the road and there's 1 block from here.
Yes. In the matters dealing with this situation, that is the application of Spies and others, 64171 of 2020, Bembe and others, 64222 of 2020, Bessels and others, 64373 of 2020, and the South African Democratic Teachers Union, 58905 of 2020. The ruling is as follows. 1. The applications are all to stand down until tomorrow, to be heard simultaneously from 10 o'clock in this court. 2. The Minister of Basic Education, as the principal respondent in all these matters, are to make the record of proceedings available to the applicants in all the matters that I've mentioned by 12 o'clock today. 3. It is noted that the Minister has undertaken to deliver an answering affidavit in case number 64171 of 2020 by 1300 today. 4. Costs are reserved. I thank you and you then all excused. Perhaps having regard to the large volume of council and others present, before I hear the remainder of today's urgent roll, I shall adjourn for 5 minutes. Court will adjourn.
It's not compiling a record. It's not drafting reason. It's a beleide decisie. Wie gaan dit ons dit hê wat sy gehad het en besluit geneem het en wat haar redes toe was. So dit moet nou compile word. Dit moet Als je daar het dat zo haalt, dan kan het wel gebruiken.
My full name.